Please be seated. The court is now back in session. The floor is once again given to Nguyen Chia's defense to continue putting questions to this witness. You may proceed.
Bonjour, Monsieur le Président.
Good morning, Mr. President. Good morning, Your Honors. With your leave, Mr. President, I would like to seek clarification in relation to your decision earlier on. Thank you.
Yes, you may proceed.
Thank you, Mr. President. First of all, I would like to specify that we repeat that we have no questions to put to this witness in the Kyrgyzstan defense team. However, in relation to the way that time was shared between the defense teams, I believe that this is a problem that may happen again, and this is why I wished to get some clarification on this matter. When this witness is examined by the prosecution and by the civil party lawyers, it appears to me that he was, the examination started at the end of the afternoon Monday, and today, if I look at the way the chamber has organized the time, we were only afforded 2 hours. 2 hours and a few minutes to examine this witness. So I understand that initially the duration of the examination for this witness was a half day on one side and another half day on the other side. But given the fact that the time has been extended for the civil parties and for the prosecution, and given also the fact that Judge Lavergne took a few minutes from the defense's time to question the witness, I wanted to make sure that in the future, and today as well, that there is true parity in terms of time between the parties. I understand, of course, that you can judge the relevance of the questions that I am raising, but however, in terms of the sharing of time, I think it is important that this sharing be fair, because the calculation such as resulting from your decision before lunch does not seem to be equitable and fair. Thank you.
The President, the prosecution, you may proceed.
Mr. President, I would just note for the record that the morning sessions of this court are 1/2 hour longer. So even with the questioning by Judge Laverne, we had a total of 2 hours from the afternoon session on Monday. The defense have had a total of 2 hours. So I think it is incorrect to represent that the defense have had less time. I would also note that counsel for Nguyen Chia chose to use almost half hour to ask questions about executions at the security office, a matter that is not part of case 00201, and chose to not once, twice, but 3 times repeat a submission and argument that had already been ruled upon by the court.
President, thank you for the observation. The chamber would like to inform all the chambers that the time allocation is absolute. For instance, minus 1 minute or plus 1 minute for any other parties. We have been in this process for almost a year, and as you have observed, the chamber tries to reduce the time for all the parties due to the irrelevant questions put to the witnesses by some of the parties. of course, the Chamber would like to extend the time to any other parties if the Chamber considers the questions are of importance and relevance to the case in hand. This morning, we observed that some questions are not relevant or are not used to its potential. For example, in relation to the questions put to this witness, referring to the statement by Henri Lockhart, as some of the portions from that statement by Henri Lockhart are unclear regarding its sources. Your questions should be substantive to the facts before this court. And the Chamber has reminded all the parties from the beginning that this witness can be questions regarding the facts of the implementation of the policy regarding the first evacuation. And the facts at the Pongro Security Center is not the one that is stipulated in the closing order. And your questions shall be supplementary regarding the local administration. If I'm not mistaken, these have been reminded to all the parties. And of course, we, judges of the bench, considered and discussed extensively as to whether this witness shall be summoned to appear before this chamber. We never take any measure as to the exact minute allocated to any of the parties. This is not what it meant. Now, the Defense Counsel, you may resume your questioning. We try to be fair to all the parties, and it is of course up to the technicality of each party to put questions to a particular witness. And we try to be patient to allow all the parties to put a question to a particular witness.
Thank you, Mr. President. Before I proceed, just to make it absolutely clear, is it correct to assume that we, the Nuon Chea defense team, have another 10 minutes and then Ying Sari team will have another 10 minutes to pose questions?
The President, the Chamber already ruled on that. It should have been cleared from this morning's session. So that kind of questions will not be repeated. It is a waste of time.
We all try to be patient, Mr. President. I will proceed under the assumption that I will have 10 minutes to ask further questions. And I will, however, have to start with a brief request for clarification. Before the break, I asked the witness whether or not he had told the investigators of the OCIJ about pressure that had been exerted on him by any authority. And this question was deemed to be irrelevant by you, Mr. President. And so that I can phrase and frame my questions, could you provide some guidance as to why this is irrelevant? Is it irrelevant to explore whether or not a witness has been pressured at all? Or are there certain circumstances in which I could explore this issue?
President, in the proceeding of the questioning, since we started from the beginning, there is no evidence that this witness has been pressured by any of the authorities. And in the written record of his interview, conducted by the co-investigating judges, there is no such evidence. For that reason, we did not allow this witness to respond to that question as there is no base.
Thank you, Mr. President. That clarifies issues. I agree with you that there is no mention being made in the written record of the OCIJ of any pressure being put on this witness. It, however, does exist on the audio record of the interview that was available to all the parties, including your trial chamber. And so my question to you, Mr. Witness, did you speak to the OCIJ investigators about a certain Ta Chun?
As for the name of that person, I did not speak of that name. I did not speak of that name through the investigators.
And did you speak of any district authority or official that's whose house you visited?
Regarding a visit to the village, I never spoke about it, nor did I speak of any name regarding what you raised.
Here becomes evident again the problem of a Dutch person trying to speak Khmer. So I would kindly ask my national colleague, Mr. Sonarun, to pronounce the name correctly so that there may be no confusion as to which name we are talking about.
The name is Chong.
So my question again is, did you speak to the investigators of the OCIJ about this person named Chong?
The person by the name of Chong in 1991, he introduced me through Henry Lockhart. However, I did not speak of this name through the investigative team when I was interviewed. Since my interview with Henry Lockhart, I never mentioned the name of Chong. And let me repeat, yes, there was a person by the name of Chong. He existed during the time that I was interviewed by Henry Lockhart.
So, did you tell the investigators of the OCIJ that this Mr. Chong pressured you to give statements one way or the other?
The person by the name of Chong, and whether I spoke of that name to the investigator team, I cannot recall it. I cannot recall whether I spoke of that name to the investigator team when I was interviewed by that team.
Did you tell the investigators of the OCIJ that this Mr. Chong pressured you?
Let me say that I simply cannot recall it, whether I spoke about that or not. So I decline to respond to this question.
Thank you. Then I would like to refresh the memory of the witness by playing this short excerpt from his interview with the OCIJ. It is less than 1 minute, and in this excerpt the witness speaks about this Mr. Chun and speaks about how he put pressure on him to speak only about good points. And once the audio recording has been listened to, and the witness confirms that it is his voice speaking, of course, perhaps he can shed some light on this issue as to in what way and why he was pressured. Clearly, this is relevant to test the credibility of the witness and the sources of knowledge. So our request is to play this short audio transcript that we have ready to be played in the courtroom.
President, the prosecution, you may proceed.
Mr. President, in principle, again, we don't object to the tape being played. However, counsel is referring to an incident that took place in 1991. I think that is of marginal, very marginal significance at this time. And there is a procedure if counsel want parts of the audio recordings to become part of the record, which is they're entitled to request that a transcript be created so that we're not here in court trying to listen to audio recordings, try to determine ourselves what is said. There is a procedure that can be followed here. A transcript can be created that can become part of the record. And I would suggest that is the better manner to proceed than for counsel to be at the last minute trying to play audio recordings in the courtroom.
Mr. President, very briefly, the issue of audio recordings has been discussed extensively. It is simply not always clear which audio recordings will become relevant, and everything, of course, depends on the answers of the witness. If this witness had simply acknowledged that he had spoken about a Mr. Chong and that he had spoken about pressure being exerted on him, we would not have had to resort to any playing of the audio records. Things come up during questioning, and again, I applaud the decision by the trial chamber earlier today to listen to these audio recordings, because I think it's crucial that the trial chamber and the public understands how these interviews with the OCIJ investigators were being conducted. So it does not need to take long. The time that we have now spent discussing it could have been used to play this excerpt 1 minute, and everything would have been clear and we could proceed. So I, again, would request the trial chamber to simply play this short excerpt, and I've been informed that the title of the audio recording is Pressure, so we could proceed very quickly if you agree, Mr. President.
President, can you indicate to the chamber what is the exact portion of that portion of the audio at what minute, so that with a proper instruction, with a proper indication, the chamber will determine and relay the instruction to the AV unit?
It is the Khmer part of the transcripts, it is the audio recording that starts at 1 hour, 38 minutes and 40 seconds. And if I understand correctly, your audiovisual officer already has the relevant excerpt and it could be played straight away.
Yes, you may proceed. AV unit, you are instructed to play the portion of the audio as requested by the International Council for Nuon Chea. That is to play the relevant portion at 1 hour, 38 minutes and 48 seconds.
So I did not speak in detail. And it might not be 100%. Because I forget some parts. If you meet me again some other time, then I will try to see all the detail that I could recall. You would clarify on any point.
Thank you, Mr. President, and again, thank you to the trial chamber to allow us to play this excerpt. And my question is simply a question for clarification. You speak of pressure that was put on you by Mr. Tachon. Can you explain to the court what sort of pressure this Mr. Tachon exerted?
Witness, yes, I heard my voice speaking about the name of the person. Ta Chong pressured me during my interview with Henry Lockhart not to speak in details. Ta Chong said, if I were to give more information to Henry Lockhart, then I would not benefit by having by receiving more money from him. For that reason, he pressured me not to speak in details. And yes, I recall that I spoke to the investigators on this point. But as I said, my memory does not serve me well. Only after hearing the tape, I recall it.
Thank you. This clarifies matters, and I am left with only one last question, if time is still available. And it's the following. Steve Hedder, who is a scholar that was employed by the OCP and the OCIJ, he has written that in practice, the most important level on both the chain of command and the hierarchy of authority appears to generally have been the districts, making district party secretaries key figures in responsibility for killings nationwide. And of course, Mr. Witness, you cannot testify about killings nationwide, and you cannot opine on Mr. Steve Hedder's writing, and I will not ask you to do so. But you yesterday, or on Monday, stated, and I quote, it is on page 99 of the English transcript and page 79 of the Khmer transcript. I quote, as stated, with regard to the logbook, this book had to go through the district level to have a final say as to whether each individual had light or serious or heavy offenses, and at the district level, the district chief would make the decision on how these people would be treated. Indeed, whether they should be executed or released, or how long these people continued to be detained. So my question to you today is, based on your experience, is that indeed how you experienced reality, that indeed the district level was taking the decisions on how people were treated and how they and whether or not they would be executed?
The President, witness, please wait to the prosecution that you may proceed.
Mr. President, we would object to this question. There was simply no legitimate reason for counsel to start his question by reading a statement from Steve Hedder, other than to try to lead, prompt, or encourage the witness to testify in a certain manner. He's been told this numerous times by the court that this is improper, yet continues to engage in this conduct in this courtroom. Second of all, he's cherry-picked and is misrepresenting the testimony of the witness yesterday. The witness was asked directly whether he knew whether district leaders had to obtain approval from the echelon above them, and indicated that it was beyond his knowledge whether or not they had to do that. So for those two reasons, we would object to the question as phrased by counsel.
Mr. President, I object strongly to the manner in which this objection was put. The prosecution has basically just fed the witness an answer, which is that he claims to not have known whether or not the district level was reporting upwards. I'm not cherry-picking. I am simply asking the witness as to his own personal knowledge. What was his experience? This is what witnesses are supposed to testify on. I know that the prosecution at times wants to assume more knowledge with these witnesses than they actually possess. I am simply asking about his knowledge, and this witness, can testify very clearly as to what he experienced. And the question is simple. As far as he could tell, were decisions as to executions and as to how to treat the prisoners made at district level. Conclusions based on that answer can wait for final submission. So, Mr. President, I would like the witness to respond.
The President. Council, please revisit your questions, and you should not link your questions to the publication by Steve Heder. You should ask the question to the witness concerning the local administration with which he was attached. And the question should not be outside of the scope, otherwise the witness may not find it possible to answer your questions, and the chamber does not have any basis whether to allow you to proceed with that line of questioning. So once again, counsel is advised to ask questions in order to get the answer to the best of the knowledge of the witness. For example, the local administration at the district level of the Democratic Cambodia. And so far, the witness could only testify to that effect.
Thank you, Mr. President. I will try to simplify the question. Mr. Witness, based on your personal experience during the Khmer Rouge regime, was it your experience that it would be the district chief that would decide on whether or not people were executed and how people were treated?
Response. According to the report in relation to the prisoner list, which were forwarded to the district office, I understood that it was not the discretion of the district level. It was forwarded to Takun, and Takun took that prisoner list and then forwarded it to the district office. And I did not know whether or not they forwarded that list to the upper authority in order to decide. That was beyond my knowledge. But to my knowledge, that list was forwarded to the district office, and it was up to that district office to decide whether to forward the list for an upper authority decision concerning the fate of those prisoners. But what I knew in addition was that those names of prisoners in the list who were marked with cross red were destined to be executed. That's what I knew at the times. But once again, I did not know whether or not that prisoner list were forwarded or relayed further to the sector level to decide. That was beyond my knowledge.
Thank you. That is all for the Nutia defense team. On behalf of my national colleague, Mr. Sonarun, and myself, I thank you very much for your answers. It's probably a moot issue now, but just for the record, the prosecution did not just have 2 hours for questioning. In fact, they started in the morning session yesterday, so they had another half hour in which they questioned. And this morning it was not a couple of minutes that Judge Lavergne questioned the witness. It was a half an hour. So should there be a time pressure for my colleague from the Ansari team, I trust that you take this into account.
The President, I hand over to Judge Civil Cartwright. You may proceed, Your Honor.
I simply wish to note that this trial involves very serious allegations against the 3 remaining accused, and time wasted in discussing whether one party or another has 3 minutes or 5 minutes or quarter of an hour to examine a witness is time wasted. You've had the ruling, and the President has made it clear that he is fair to every party. Can we please stop addressing such minor issues?
The President. Next, I hand over to the defense team for Mr. Ieng Sari to put the questions to the witness. You may proceed, Counsel. Counsel Angadam. Good afternoon, Mr. President. Good afternoon, Your Honors. Good afternoon to the prosecution team and parties and members of the public in the public gallery. And good afternoon, Mr. Pechui Chip Sai. My name is Angadam, and to my right, Mr. Michael Canavas. He is my co-counsel for Mr. Ieng Sari. I would like to put a few questions to you. I do not have many questions, and I hope that my question is not repetitive. I ask for clarification from you, but before I proceed with my questions, I would like to concur with the question from the defense team of Mr. Nguyen Chia. I concur with him in the sense that we agreed that we should play this short recording for the parties and the chamber. And this morning, the witness testified that he could not recognize his own voice, and he was not certain whether or not that recording belongs to him. And Mr. Chipsai, you responded to the question put by Judge Nilnund and Judge Lavange, as well as the question put by the defense team for Mr. Nguyen Chia. You said that you had 2 interviews with the investigators of the Office of Co-Investigating Judges. And you also further asserted that before testifying before this chamber, you also examined the record of interviews with the OCIJ as well in order to refresh your memory. I would like to ask you in this respect, how or to what extent have you read your record of interview before you came to testify before this chamber? Response. Before I came to testify before this chamber, I read the question and answer in the record of interviews, but to what extent I cannot really tell how much I have read from it, but I did read the record of interview prepared by the investigators of the Office of Co-Investigating Judges, and I do not even recall how many questions and answers there were in that record. Counsel, thank you. I would like to now go to the substantive matter. I don't want to dwell on it too much because it concerns mainly on the operation or operational work of the security office. But unfortunately, I have to mention that the security office is not within the confine of the current case before us, but since party has asked a question concerning this issue, I would like to simply touch on this issue. And Mr. President, I would like to seek your leave to present a document to this witness, document D125/125. I would like to ask your leave to present this hard copy document to the witness and have it put up on screen as well. I will not ask any question concerning the substance of this document, but I would like to simply ask Mr. Chipsai whether or not he knows this witness whose name is in this document. The President. You may proceed. A court officer is instructed to obtain the hard copy document from counsel and hand it over to the witness. Counsel. Mr. Chipsai, the documents that I am presenting it to you is in document D125/125. Khmer ERN 00224060. English ERN 00240039. French 00240044. Mr. Chipsai, you responded to the question posed by the President as well as parties to the proceeding that you serve in the security office, Bungro Security Office from 1974 until 1977. And you also asserted that you worked then in a capacity as the security office clerk. Do you stand by this statement? Response. Well, there was no de jure position as a clerk as such, but it was the title I thought that my position was at that time, because I kept a record of the confession of the prisoner detained at that security office. At that time, on the de facto basis, they consider me as a clerk. I was the one who was in charge of keeping records and documents. That's why I have considered myself as a clerk ever since. Counsel. So if you now look at the document I am presenting to you, please do not mention the name of the witness yet, but on the very first page of this document, do you know this particular witness? Response. Yes, I do. Counsel, thank you. For your information, this particular witness has provided testimony to the investigators of the OCIJ, and the interview was conducted at the same time or contemporaneously with your interview as well, because this gentleman was interviewed by the investigator in the morning and you were interviewed in the afternoon. And once again, on the same page, if you look at page 4, to put it bluntly, page 4, I would like to quote some of the statement by that witness. The question asked, what was the chairman of the security office or security section? And you say Kun was the person, and Niet was the deputy chairman, and Pei Chui Chipsai was a member. So it means that you were a member in the Bungro security office. How would you comment on this statement by this particular witness, which designated you as the member of the security office of Bungro district? Response. Well, there were many people who believed that I was the person who was in charge of Bungro security office. Well, because at that time I was close to Takun. That's why many people understood that I was someone very close. I could have been the deputy chief of Takun at that time. But once again, as I testified earlier, there was underground organization, and in that organization, my name was not there. As I said, in this underground organization, the composition were those from the Youth League of the CPK as well as the party members. So I was there in the security office, but I was not in the underground structure of the Khmer Rouge. So I was not someone who is playing any important at that time. Question. Now, if you say you know this particular witness, what was his role at the Pungro security office? Response. For this particular witness, I cannot recall his exact role in the security office. I don't really know what his position was, but he was located somewhere around Praise 5. Pungro Security Office has a cell, a smaller cell, located somewhere in Praise 5. It was not in Punlu Post village. It was far from the village, and this particular witness was an officer in charge of this security office cells. Thank you. But if we go back a little bit and look at the first answer to the question by the investigators, it is in the same document. He said that after that, in 1975, I was designated to work at the Pungro Security Office. Just now, you testified that it could have been a mistake by that particular witness concerning your exact position over there. So I would like to once again ask you whether or not you reject the statement by this particular witness concerning your role at security office. Once you clarify this, I will not go further in relation to this matter. Response. The testimony of this particular witness concerning my role at Pungro Security Office, I categorically reject this statement. Of course, I was a clerk at the security office, and I was from the Piti bourgeoisie class, so I was not supposed to be in the structure of the Khmer Rouge. So any statement amounting to the fact that I was holding a position of importance in that security office was wrong. Counsel, thank you, Mr. Witness, and I do not have any further questions, and on behalf of my international co-counsel and myself and the whole defense team for Mr. Ieng Sari, I thank you very much for answering our question, and I wish you the best of luck. President, how about the defense team for Mr. Kyu Sampon? Have you changed your mind? Do you have any question to put to the witness? Counsel. Thank you, Mr. President. On behalf of the defense team for Mr. Kyu Sampon, I do not have any questions to put to this witness. Thank you. The President. Thank you, all parties. Mr. Pe Choi Chip Sai, your testimony before the chamber has come to a conclusion now. So you are now released. You can go to go back home or go to any destination you wish to go. And the chamber, on behalf of the bench, I would like to thank you very much for taking time to testify before this chamber. And I can assure you that your testimony contributes to ascertaining the truth for this case. And I wish you the best of luck and safe journey back home. Security, the court officer is instructed to facilitate the transport of the witness back home. And Mr. Chipsai, you are now released. And Duty Counsel is also released. You may go back home. The time is now appropriate for an adjournment. The chamber will adjourn now until 20 to 3. And in the next hearing, we are going to hear the testimony of TCCP 82. The court is now adjourned.
សូមអញ្ជើញក្រោយឈរ